All right, let's call this meeting to order. Let me first start with attendance. I know we have a new commissioner here I'll start with who has some people ready to ask questions. Questions are allowed at any time during this esteemed proceeding. Commissioner Jumper.
Good morning.
Commissioner Vassallo.
Present.
Commissioner Caruso.
Present.
Commissioner Parcells.
Present.
Commissioner Reddycliffe.
Here.
And I am here, so we're up to our sixth complement. If we can ask the Senate Republicans to make an appointment, we will then be a full seven, which we would love. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive meeting will be held today, July 23rd, 2026, immediately following this session to review matters that by statute are confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review and consideration of an application for 90-day extension of investigation filed by the Investigative Division, and administrative matters. So on our public meeting agenda, the first item is the April 16, 2026 public meeting minutes. Has everybody had a chance to review them? May I have a motion to adopt those minutes?
So moved.
A second?
Second.
Any questions, corrections about those minutes? Hearing none, all in favor of adopting those minutes say aye.
Aye.
Any opposed? No, the minutes are adopted. Let's start with the civil penalty orders by consent. Commissioner McKee-Vassallo.
Sure. So I understand that there's only one by consent. Correct. Okay. And so we will take up the one civil penalty case with a proposed consent agreement for our consideration. This case involves Robert Demotte or Demott, maybe mispronouncing it, failed to timely file a statement of financial interest for calendar year 2024. The parties in this case have submitted a consent agreement proposing that the commission find that the respondent failed to timely file a statement of financial interest for the year stated and impose a civil penalty that I will detail in my motion. Respondent has also agreed to file his delinquent statement of financial interest. Based upon my review of the facts, I am of the opinion that the consent agreement is the proper disposition of this case. It is my opinion that the commission should impose the civil penalty agreed to by the parties per the consent agreement. It is further my opinion that the commission should order the respondent to file his delinquent statement of financial interests to the extent he has not already done so. There is nothing of record that would constitute a defense or excuse for noncompliance. So based upon my analysis of the papers and comments, I would like to make the following motion. I move that this commission approve the consent agreement submitted by the parties imposing a $100 civil penalty against respondent Robert Demotte for failing to timely file a statement of financial interests for calendar year 2024. I further move that to the extent that the respondent has not already done so, respondent shall be ordered to pay the recommended civil penalty amount agreed to by the parties per the consent agreement within 30 days of the issuance of the commission's order. And lastly, I move that to the extent the respondent has not already done so, he be ordered to file a complete and accurate statement of financial interests for calendar year 2024 within 30 days of the issuance of the commission's orders.
Very good. Do we have a second to that motion? Right. Any questions about this matter? Hearing none, all in favor say aye.
Aye.
Any opposed? Motion carries. So now we have 8 civil penalty defaults, but we'll take them the first 7 because I understand on the 8th one, Commissioner McKee-Vassallo is recused.
Yep.
Okay. So Commissioner Jumper, for your debut at the commission, can you please explain the 7 defaults that we have?
Yes, and I've been practicing, so hopefully I get through this well. 7 civil penalty default cases are now before the commission for decision. The respondents involved in these cases will be identified individually in in the motion I will be making with regard to these cases. These respondents failed to file statements of financial interest for the calendar year that I will detail in my motion. The respondents did not take action or otherwise respond to the civil penalty proceedings. Following review, it is my opinion that as to each respondent, the Commission should levy a maximum civil penalty for each delinquent statement of financial interest. It is my opinion that the Commission should also order these respondents to file their delinquent statements of financial interest. There is nothing of record that would constitute a defense or excuse for their noncompliance with the requirements of the Ethics Act. Based upon my analysis and comments, I would like to make the following motion. I move that this Commission levy maximum civil penalties against the respondents in the following civil penalty default cases as follows. I move that this Commission levy a maximum civil penalty in the total amount of $250 against the following 5 respondents for failing to file a statement of financial interest for calendar year 2023. Ann O'Hare, Shakina Tate, Dawn Durst, Ricardo Almodovar, and Terry Cray. I move that this Commission levy a maximum civil penalty in the total amount of $250 against the following 2 respondents for failing to file a statement of financial interest for calendar year 2024, John Wolkowkas and Heather McGrath. Further, these 7 respondents shall be ordered to file and complete an accurate statement of financial interest for the years stated within 30 days of the issuance of the Commission's orders.
We have a second to that motion.
Second.
Right. And just a comment, I think just especially for Commissioner Jumper and those who are visiting us, the Commission offers opportunities to cure the delinquent filing without even going through the civil penalty process. Then offers an opportunity for mitigation through a consent, as we saw where the penalty was lower. These are all folks that have not responded to either of those and therefore are being penalized at the statutory maximum amount. So with that, all in favor of Commissioner Jumper's motion? Aye. Any opposed? Motion carries. And just for the record, you are recusing from the matter of Genslinger. Do you want to put a brief statement why?
Sure, so my firm has a representation of this individual, where I will recuse myself. Do you also want me to put on the record why I'm going to recuse from the next matter as well?
Certainly, so we'll keep you outside for 2 matters.
Maybe I'll come back.
And that's the consent decree for the United Way of Greater Philadelphia and Southern New Jersey.
Correct, and my firm also represents the entity at issue, so I will recuse.
Very good. We'll call you back.
I'll just stand.
So Commissioner Jumper,
Yes.
you have the Genslinger matter.
Yes. Respondent Justin Genslinger, a public official or public employee, failed to file a statement of financial interest for the 2024 calendar year. The respondent did not take action or otherwise respond to the civil penalty proceedings. Following review, it is my opinion that as to Respondent Genslinger, the Commission should levy a maximum civil penalty for his delinquent statement of financial interest for the calendar year 2024. It is my opinion that the Commission should also order this respondent to file his delinquent statement of financial interest. There is nothing of record that would constitute a defense or excuse for his non-compliance with the requirements of the Ethics Act. Based upon my analysis and comments, I would like to make the following motion. I move that this Commission levy a maximum civil penalty in the total amount of $250 against Respondent Justin Genslinger for failing to file a statement of financial interest for calendar year 2024. Further, this respondent shall be ordered to file a complete and accurate statement of financial interest for calendar year 2024 within 30 days of the issuance of the Commission's order. This is my motion.
Is there a second? Second. All in favor, or any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. All right, we're going to turn to administrative penalty orders by consent for lobbying. We have two of them, but let's split them because Commissioner McKee Vassallo, as we just stated, was recused from the United Way of Greater Philadelphia and Southern New Jersey. Commissioner Parcells?
There's one administrative penalty case with proposed consent agreement for our consideration. Respondent, United Way of Greater Philadelphia and Southern New Jersey, failed to timely file a quarterly expense report for the fourth quarter of 2025 in its capacity as principal. Parties agree that the respondent's transgression of the lobbying disclosure law was negligent. Respondent has now submitted its delinquent expense report to the Department of State. Based on my review of the facts, I'm of the opinion that the consent agreement sets forth a proper disposition for this case, and I would like to make the following motion. I move that this commission approve the consent agreement submitted by the parties and oppose the following administrative penalty. As to the United Way of Greater Philadelphia and Southern New Jersey, one administrative penalty in the total amount of $4,000 for its delinquent expense report for the fourth quarter of 2025. I move that the respondent be directed to pay the administrative penalty to the commission by no later than 30 days after the issuance of the commission's report.
Is there a second to that motion?
Second.
Right, any questions, comments? Right, all in favor, say aye.
Aye.
Any opposed? Motion carries. All right, do we want to ask Commissioner McKee Vassallo? We now have the administrative penalty consent order for William Penn Human Services.
So respondent William Penn Human Services failed to file a timely quarterly expense report for the fourth quarter of 2025 in its capacity as principal. Parties agree that the respondent's transgression of the lobbying disclosure law was negligent. Respondent has now submitted its delinquent expense report to the Department of State, and based on the review of the facts, I'm of the opinion that the consent agreement sets forth a proper disposition for this case, and I would like to make the following motion. I move that the commission approve the consent agreement submitted by the parties and oppose the following administrative penalty. As to William Penn Human Services, one administrative penalty in the amount of $3,950 for its delinquent expense report for the fourth quarter of 2025. I move that the respondent be directed to pay its administrative penalty to the commission by no later than 30 days after the issuance of the commission.
Is there a second to that motion?
Second.
Any question or discussions? In favor, say aye.
Aye.
Any opposed? Motion carries. Commissioner Caruso, we have a default on a lobbying administrative penalty.
Thank you, Mr. Chairman. There is one default administrative penalty case for our consideration. Respondent Urbane Development Group Ltd. is a registered principal that failed to timely file either a quarterly expense report or a statement of failure to meet the reporting thresholds for the third quarter of 2023. A warning notice was issued to the respondent, but the respondent failed to comply within the 30-day cure period provided. Based on the record before us, it is my view that the respondent's transgression of the lobbying disclosure law was negligent. Respondent has now submitted its delinquent expense report to the Department of State. I move that this commission levy upon respondent Urbane Development Group Ltd. one maximum administrative penalty in the total amount of $27,300 for its failure to timely file with the Pennsylvania Department of State either a quarterly expense report or a statement of failure to meet reporting threshold for the third quarter of 2023. Finally, I move that the respondent be ordered to pay the aforesaid administrative penalty by no later than the 30th day after the mailing date of the commission's order. That is my motion.
And Commissioner Caruso, was this entity a prior, subject to a prior penalty order?
Yes, when I received this assignment, I thought the name sounded familiar. And so I Googled it just to try to see who the company was, and the first thing that popped up was the commission's prior order in, when was that? That was also for the prior quarter of 2023. And the commission at that point had levied a $30,000 penalty, and I'm not sure, maybe Mary or could address that.
Sure, we had in place an agreement with Urbane that they would make regular payments and we would hold off on filing third quarter failure to file an expense report. They failed to do so. I reached out, some personnel changed, so I got in touch with a new contact person there. They assured us they would continue and get back to making regular payments. They never did. That matter was then referred to the Attorney General's Office Financial Enforcement Section for collections.
Thank you. I think that's helpful, and I think that's important under Penn Film Group, where we're supposed to consider whether in a default case, the maximum penalty or something less should be imposed. Certainly sounds to me like that's an additional factor to be considered with respect to the motion. I don't think I asked for a second to that motion yet.
Second.
Any further discussion? I think I jumped the gun on the discussion piece of this, but
I just have a question as to how many days late it is. I think there just might be a typo, and I apologize for not flagging this beforehand on paragraph 18 of page 11. We threw both 80 and 70 days, so I just want to make sure we're actually calculating the right amount.
That is a typo. Actually, Mary Fox pointed it out to me.
Okay, sorry, I
And
didn't point it out beforehand.
No, we've changed it.
Okay.
So the order that goes out, it is 70.
It's 70, okay. So we calculated it
Yes.
accurately.
so the amount in the motion
is the
is
same.
based on 70
Yes.
days. Okay, thank you for raising that.
I have one other question. Are they still registered as principals?
I believe that they are, but I can double check.
Towing my car.
Looks like it expired. It has expired at the end of 2025.
All right, so we have a motion, we have a second. Any further discussion or questions? Hearing none, all in favor say aye.
Aye.
Any opposed? Motion carries. All right, we are moving to administrative matters, and Ms. Guilfoyle, can you give us an update on our regulation process?
I certainly can. Excuse me. This may be a little bit long, but I wanted to make sure that we get everything in that we need to
Please.
discuss. As you're aware, we delivered our proposed rulemaking to ERC and the standing committees on April 6th of 2026. And then it was published in the Pennsylvania Bulletin on May 2nd of 2026. That is the beginning of the 30-day public comment period. The 30-day comment period resulted in us receiving only a set of comments from one particular body, which was the City of Philadelphia Board of Ethics submitted a lengthy comment sheet to us. These comments actually mirrored the comments that they made when we did the exposure draft, I believe it was last June. And we discussed most of them at that meeting and decided how to proceed, or in some cases not to proceed. So unfortunately for us, the Regulatory Review Act requires that we respond to them in our updated preamble that we are going to be submitting as our final form regulation. Excuse me. So the document that is in your agenda is a listing of the comments that they made as well as the response that I'm proposing to be made. And I will just hit the highlights of the one, of a couple of these. I mean, the term business, we've talked about this a lot, about including the nonprofit in the definition of business. Or, I'm sorry, not in our definition of business, in the certain places where a nonprofit matters in our regulation. The Philadelphia Board wants us to add a definition of business to our regulations and include in there the language about it including nonprofits. I had some concerns about putting in a definition because the statute already has a definition of business in it. So I reached out to Amy Elliott of the Attorney General's office, who had reviewed our regulations before we sent them out as a proposed regulation. And she said that we could in fact do a definition of business if we wanted to. We would be allowed to include that additional language above what the statute already says because of the Supreme Court case involving Rendell. However, she pointed out something that I had not thought of, which was the fact that we do use business in other ways in the regulations. I looked, we have 24 instances in which we use the term business, and less than half of those are ones that we would be including the nonprofit language for. So if we add a definition and include nonprofit, that means we're going to have to do a carve out for every other instance that we use the term business and don't intend to include the nonprofit, most notably in our section regarding financial interests. So my recommendation would be to proceed as we were, which is to put the carve out when we want to include nonprofit, as opposed to when we don't want to include nonprofit and adding that definition. I think that's an easier way to go, and it will be very clear that we are when we are including nonprofit and when we are not.
Should we take each of these issues one by one just to see if there's any questions on? Does that make the most, or would you like to wait till the end?
No, I would prefer that we do it as we're going along.
So let me suggest that we take any questions and then take a quick vote as to whether to adopt the response that is being proposed. So with respect to business, anybody have any thoughts?
Bridget, did you get back to the Philadelphia Board of Ethics?
I have not.
Okay.
Our getting back to them will entail the new preamble, which will be sent to them when we send out our final form regulations, because they are a commenter or commentator, whichever you prefer. They will be getting a copy of our final form regulations directly from me.
But it also may be a good idea, just following up on that, to let them know that we discussed each of these issues today and what we decided to recommend, and certainly they can watch the video if they want to hear any of this discussion.
I can do that.
I don't think the response is currently drafted, though, includes the way in which you intend to fix it. Is that, do you intend for the response to have that information, or just to explain why we're not doing it? So what I heard you say is that you will add a carve out where nonprofit is intended to be
Correct.
referenced, and I don't.
That's what we currently have. So
Okay,
that's what we currently have in our regulations.
okay.
We did not have, we did not have a definition of business, and we did not have any carve-outs for when nonprofit is not included.
Okay.
So yeah, it's currently as it stands.
So the response is intended to say we're standing on what we have done and not
Yes.
explaining, okay, understood.
And explaining why we went in that direction.
Yeah. Okay.
So let's, on that issue, all in favor of the recommendation as proposed?
Aye.
Aye. Any opposed? Let me go back. Did I have a motion to adopt that recommendation?
So moved.
Do a second for that. I don't want those that used to be in the legislature to raise any parliamentary procedure. So we have non-pro-tunc approved that. Go ahead.
Okay. The second comment that I thought was important was the de minimis economic impact. As you'll recall, we attempted during the exposure draft process to come up with some definition for de minimis economic impact, and I don't think it's unfair to say that our efforts did not go well. When we sent out the exposure draft, I think nearly every person that had a comment on our regs commented on that section, said it was confusing, that it was either not what the statute intended, and so on and so forth. So ultimately, we decided to just leave the de minimis economic impact the way that it was. The reason that I want to put an answer or a response in here is so ERC knows and the Philadelphia Board of Ethics knows that the reason that we're not doing it, and that's, I mean, it's pretty simple why we're not doing it, is de minimis economic impact can mean many things to many people depending on the contextual circumstances. It's not impossible, but it is virtually impossible to come up with a definition that would take into account every possible context that we would be looking at whether something was de minimis or not. And ultimately, I think that decision is up to you. In one circumstance, it could be $2,000, and in another circumstance, it could be $300. I really think that it depends upon the circumstances, so that's why I believe that we should not be putting in a definition, and that was the reason that I added a response to the Philadelphia Board and that'll be on our preamble about this.
And it sounds, we have had many cases, consents and otherwise, that have raised that issue. And I think we have taken it on a individual case, fact and circumstances basis, and you can get some guidance by reading those. But I agree with you that to say it is a particular amount becomes fraught with trouble because it does depend on the facts and circumstances. Do I have a motion to approve that recommendation? Okay, and a second? Second. Right, all in favor of that recommendation regarding de minimis economic impact? Say aye. Aye. Any opposed? That recommendation motion carries.
The remainder of the comments that we received from the Philadelphia Board were on issues that we had not either discussed or that we have not changed or did anything with in the regulations. So I struggled a little bit with how to respond to something that we didn't do. And so I reached out to the Office of General Counsel as well as to the Regulatory Counsel at the Department of State to find out, do I need to respond to comments that are just, you should have done X, Y, and Z. Their response was that, which is the response that you'll see in the materials, is that I could do a generic response saying, this is not something that was included within the proposed rulemaking, therefore we are not going to comment on it. However, in future rulemakings, we will consider this. After I wrote this document, and the more that I thought about it, I'm going to actually give you another option in this, instead of the generic option. The reason that I'm doing that is after we received the comments from ERC, I think that we might be better off if we at least had some sort of explanation as to why we didn't do something or why we can't do something. And so I think there's three of them that, one of them is the use of the term employed by. We only use it in terms of what, as it applies to you, as to commissioners. We don't use it in the rest of the definition only applies to the section involving union code of conduct. They want it to apply universally, at least in terms of chapter 23, which chapter 23 is, again, applies to the commissioners. So I think it's better that if we're going to make a comment, then I think we should explain that it already does indicate that it applies only to the commissioners. We tend to stand on that issue. The governmental body question that they asked us, or to include a definition, or what factors or considerations that the commission uses. Anytime someone's asking about factors or considerations, I think we run into difficulty because I don't think we want to limit ourselves to some of the things that we may have considered in the past when there might be additional considerations based on what the particular facts of that case is. So, and the other thing that I would want to put in is that we already have a statutory definition, or a detailed definition of what a governmental body actually is. And so I think that that is what we should probably put in there. With all due respect to the Philadelphia Board, I think they are a very unique entity in that their structure is so much more extensive than anybody else in the Commonwealth, including Allegheny County, which is Pittsburgh. The flow chart of their governmental body is almost something that you can't even follow because it's that large. So I think that we should stand on the fact that we already have a definition for what a governmental body is, and we should avoid putting in factors or considerations as to what we should consider when determining whether somebody is, in a certain governmental body. Then that would, of course, affect their post-employment restrictions. I think we're better off if Philadelphia runs into an issue that they can write in for an advice of counsel, and we will handle it that way rather than changing the regs primarily just to suit the one large city in our state. And the last thing, which they want us to codify the definition of the conflict of interest. We have an extensive body of case law, advisory opinions, and advice of counsel on what a conflict of interest is. Again, I think it's nearly impossible to codify all of those things into a neat, tidy definition of, other than what we currently have, of what factors or considerations we are looking at in a conflict of interest. I think the definition is clear. What generally isn't clear are the facts surrounding whether it will be a conflict of interest or not, and that's something that I think we should be taken on a case-by-case basis. But given that Eric commented on whether we considered the recommendations from Philadelphia, I think that rather than a generic response, or maybe add the generic response of we will consider this in our future rulemakings, I think that we should probably put something in like I've just talked about as to why we're not doing what Philadelphia is suggesting. I think that's what IRC is looking for, and I think that it should be handled in that way.
That certainly makes sense to me, and I do like the idea for almost each of these, even de minimis in some respects, that we do have an option of seeking advice of counsel. Now, that may be harder to put out the facts for a de minimis determination, but certainly we have offered opinions on conflict of interest before. We have offered opinions as to whether certain positions fit the definition of a public employee or a public official subject to the act. My sense is being more addressing of each of the issues is better than just a pure generic answer. But what do other people think?
I would agree that to get away from the generic, some more specificity.
I think I'd wanna see what the more specificity is, because I don't wanna paint, and I appreciate, Bridget, that you're thinking through this in between when you drafted it and sent it to us. I think we should probably look at the language at some point to make sure that we're not painting ourselves into something that could then be used as demonstrating how we view the regulations as currently drafted. But I think it's fair to provide more detail as to why we made certain decisions.
What will happen is I will draft it's called a comment and response document that gets attached to the preamble. And it will be presented to you at the October meeting for final approval. If there's something in there that needs changed or you want to change, we can certainly do that at that point.
So for today's purposes, I would move that we authorize Bridget to prepare the response as we've just discussed. And I think Commissioner McKee-Vassallo's point is well taken, subject obviously to our final approval of the response going out. But this way, I think as part of the process, today's meeting, public meeting and discussion shows that we gave consideration to the comments. We've discussed them as a commission, and this is the direction we're taking. So with that, I would make a motion that we accept the second recommendation of Bridget, the more detailed response as she's described, subject to our final approval.
I have one question though.
Go ahead.
We're under a bit of a time crunch here, aren't we?
We have 2 years from the close of the public comment period to submit the final form regulations. So the close of the public comment period was June 2nd of this year.
Okay.
So we have 2 years from
Okay.
June 2nd to get it back across the hall or across the road and over to ERC.
Okay.
So I think we are good on time.
Doesn't feel like much of a time.
Yeah, I was thinking legislative sign and die and.
Yeah, I'm wondering, that was my question, because how does the fact that this is a sine die year
Year.
affect the regulatory process?
It's only affected if we are attempting to serve during that time, I believe. So I don't think that ours would die in the standing committees if it's a sine die year. But I will look to
I
make
should
sure.
know that and I don't, but that was my concern.
Why don't we look into that, because if we needed to,
do a
to speed up the
phone meeting.
process, we could call a special meeting beforehand. We definitely want to both responsibly address these issues, but at the same time, move the process forward so we don't have to start.
Yeah, the last thing we wanna do is start over.
Right.
I agree with you wholeheartedly, Commissioner Parcells. So that was the Philadelphia Ethics.
Okay, let me pause. I think I made a
You did.
motion, but we didn't have a second.
Second.
And all in favor of that last recommendation, say aye.
Aye.
Any opposed? No. So you have the commission's view of those recommendations.
Thank you.
And then let's find out the issue of timing, if there is a concern because of the legislative session. If there is, I would ask if you could put this together sooner and let's schedule a special meeting just to consider that. That would have to be a public meeting, so we would need enough time to advertise. Anything else on regulations?
Actually, yes.
Go ahead.
I told you this was not going to be short.
That's okay.
The comments that we received from ERC, I would like to receive some feedback from the commission on. ERC submitted their comments to us earlier this month on July 1, and their main concerns are, I think they have 3 main concerns. The one is that they want us to clearly explain how stakeholder input was evaluated, incorporated, or otherwise addressed during the development of the rulemaking process. And I think that leads directly back to the comments that we received from the Philadelphia board. I think they want to know what types of comments we received during the process. And I think we need to flesh this out a little bit more, including we had a great deal of involvement from the Office of General Counsel on certain things. And I think that I need to flesh this out a little bit more and explain how they were involved. The things, I did explain what we did and how we did it, but I don't think that I explained enough of what considerations we had when it came to the suggestions made by individuals or entities that were here. So I think that that is something that can easily be buffed up a little, or beefed up a little bit. So, the other one, or the second one is not quite as easy to deal with. We're back into this Rendell issue again. And I received a call from the chief counsel over at ERC asking about this specific issue. Basically wanting to know why the commission hadn't done anything since 2009 to make sure that people were aware that nonprofits were now included in the definition of business. And we also had the chief counsel asking whether people should be filing amended SFIs based upon this. And obviously, I don't think any of us were around, maybe Martin, who's ignoring me right now. Martin, of course, was here during that time frame, but there's not a lot to say as to why we didn't, but Martin actually came up with a very good point, which I did not know. The Rendell decision, and I've always referred to it as the Rendell decision that now includes nonprofits in the definition of business. When talking about it with Martin, Martin very astutely brought up the fact that Rendell did not change anything. It simply affirmed the commission's long-standing opinion that nonprofits were included. And it wasn't until there was a challenge to that opinion from the commission that we ended up in court with the Rendell decision. So we've always held the opinion that nonprofits were included in the definition of business. The court just affirmed what we had already been doing. So I want to make sure that we bring that out, that had always been the case. And they're also asking us about, are we revising the SFI instructions and the document to make it very clear that this now includes, I hate saying now, this includes nonprofits, and Mary and I have talked about it, and we are going to do an updated form, and Mary's also working with the people that did the electronic filing system to make sure that instruction is on the form. We will have to attach the paper form to our preamble when it goes out as a final form. They also want us to describe how we are going to inform the regulated community of any future changes in statutory interpretation affecting their filing obligations. I'm not quite sure how to answer that question, Mary. Maybe you can help me with this a little bit. I mean, I know that we can, advertise on our website and we can put it on our social media and things like that, but that is not, I don't know that that's a good way or a total way to cover everybody that we have to worry about covered in our regulated community. But I'm not sure what else that we can do other than advertising maybe in the Pennsylvania Bulletin, which most people don't read.
I would recommend that when we have statutory changes or court decisions that interpret the statute in a way that maybe lends clarity or changes to our the previous way that we were regs, that we change instructions, of course, for the next go around for printing statements of financial interest. That's an easy thing to do. Include those changes in our trainings and our outreach, that we're doing the best we can with getting that word out. Social media, of course, in terms of our LinkedIn account and posting to our website. We also maintain a mailing, like an email list, and we can send out notes that way as well. I think it's the best that we're able to do at this point.
And we have our annual report,
We do, of course.
and that's statutorily required, so we will put any of those changes in there. It seems like all of that should be in response. I do think it's important. I thought, and maybe it's just because I knew nonprofits were included, but I thought from the instructions, you know or have a good sense of nonprofits being included, because I sit on the board of a nonprofit and I always disclose that nonprofit.
So I review the instructions for all of the statements of financial interest, going back to, we have them back to 1979, I believe. And it was never explicitly laid out in the instructions in the form, and there was no change in the 2009, 2010 timeframe when the Rendell decision was issued. So it's probably because we had the perspective that they've always been included and there was no need to change, but given the concerns that were raised, I'm certainly happy to make it more explicit and more obvious.
So let's do that, and probably we would need to have that updated form attached as an exemplar to our response, and, you know, I guess it's a good time now, because whether or not the regulations go through, let's use that updated form for the 2026 disclosure year, which would not be due till May 1st of '27.
Absolutely, and we'll update, I'm thinking about the new system, the new SFI filing system. We can add as there's a small I with a circle around it that gives explanation, but we may be able to build that into that question more explicitly into the form to seek that type of answer about affiliations with nonprofit organizations.
Mary, I know you reach out to a lot of organizations. Wouldn't it be helpful just to reach out to the Pennsylvania Nonprofit Association
Sure.
group? It's a statewide membership organization that I think would love to, have you give an overview.
Yeah, I'm certainly happy to do that. Other things, like PSAT, State Association of Township Supervisors and the like, we have contacts with all of those organizations. We can reach out to them and ask them to maybe push out a notice to their members, an electronic notice to their members, and then add that to their training when we're not going to be actually there. I'm happy to do that.
I think that should handle that, all of the questions surrounding the Rendell opinion. The last thing that I think needs discussed is IRC 1C. In an oddly worded paragraph, they want clarification on how our change in the definition of public employee would require certain individuals to file. So we've changed public employee to include language that anyone with responsibility over the tangible economic benefits of their subordinates. Specifically, they asked about the head of maintenance at Forum Place, the supervisors of secretarial pools within the Commonwealth system, and the supervisor of floor pages in the General Assembly. I would imagine that we will go about, I'm not totally sure how to respond to their specific ones without having job descriptions of what these individuals do, and I mean, just knowing their title is probably not all that helpful as to whether they're going to fall within the definition of public employee or the new definition of public employee. Someone can be the head of maintenance, but I'm not sure that what they do gives them authority over their subordinates' economic benefits. So I'm struggling a little bit with how to respond to this other than to say that we would review these as we would review any other request for a determination as to whether someone is a public employee or not. But in terms of these three specific things that they asked about, I'm going to probably have to say that without a job description for these positions, that it's not possible for us to determine whether they would fall.
Going back just a bit, are we really changing the definition, or are we clarifying what already is the definition again? What we're saying is a factor to be considered is whether or not you can control economic decisions affecting subordinates. That has always been a public employee. I don't know that we had articulated that in our definitions before, but our decisions have always considered that as a factor.
So I can handle that sort of the way that we're handling Rendell, is that it's not so much a change as it is a clarification
additional guidance of what already was a public employee. And for their specific examples, like any position that people seek input as to whether they or meet the requirements of public employee for purposes of disclosure or other Ethics Act issues, it is a fact-based determination. We need to see the job description and have all of those circumstances, and we routinely will issue an advice if asked about that.
And if I may also mention, it does come up from time to time that someone discovers they were supposed to file, they're covered by the act, and they realize that they didn't file. And we deal with that a number of ways. Usually we'll have our administrative staff connect with that person and help them get the filing completed. We're really trying to get compliance when it comes to statements of financial interest. And I want to note that we also provide people 2 opportunities of a cure period. So we provide them a notice and we say, hey, you think you're covered and you have to file, and if you file, nothing will happen. And we do provide a second notice by certified notice. So we take a lot of steps to help people who, who haven't filed, and we're not looking to penalize, we're looking to get them in compliance. So we already have a process in place, and we already have had this happen before, where someone discovers they were supposed to file and didn't.
That's helpful, thank you, Mary.
Any other thoughts on this? I think this is more feedback for you, Bridget, than a specific, are we going to adopt something? But I think we do want to respond to ERG, and I think with this feedback, we leave it to you to prepare a draft of that response that we'll take up at our next meeting.
The only 2 other things they mentioned were very small things, one was a typo by me.
Let's
Yeah.
correct the typos.
Well, we will do that, there was only one, that I'm aware of. And the other one was, to consolidate the subpoena process into.
Have an operational report from Mary?
Thank you. Yes, so from a financial standpoint, we're looking very good. The budget has since passed. It was passed July 12th. We received $4.118 million, which is what we requested. I was very, very happy to hear that. And that'll allow us to continue the work that we're doing, as well as continue to provide appropriate pay increases to staff, reflective of, well, I'll discuss that in my next agenda item. In addition, we have closed out our fiscal year 2025-2026 budget. We had a surplus of $189,884, and we have requested, on July 8th, we submitted a request to carry that over to be used for operational expenses in this fiscal year. We have not yet heard back, although I'm hopeful that we will have. And we also have a continuing appropriation fund with a balance of $176,935. So we're looking very good from a financial standpoint. I want to say thank you to the commissioners that accompanied me to meet with the heads of the appropriation committees and the caucus leadership. Very fruitful, and as a result, we have the budget that we need to move forward and continue this work.
And we have a volunteer and
Yeah, we
commissioner
do.
jump in to continue next year's begging and cajoling for our budget.
We continue to do a lot of external trainings. Jen Lehman and our other attorney, Julie Caravan, and I handle most of those trainings. We handle all the trainings. So far this year, we've done 31 in-person or virtual trainings. We've reached approximately 1,600 public officials and public employees. We currently have 10 more scheduled for 2026. We will teach and talk to anybody that will listen to us about the Ethics Act. So if anyone knows of someone who might be benefiting from training, send them our way, and we're happy to do whatever we can to continue that instruction. One other thing that was really positive this year, we actually received a lot of happy feedback from during the budget meetings, is that we received from the Continuing Legal Education Board accreditation to offer CLE credits We've done that now in a few of our trainings, we have more coming up where we'll be offering CLE credits. But we've gotten a lot of great feedback about that. And we'll continue to offer the CLE credits for those trainings. That's great. I think it's really important that we reach solicitors. I think it's really important that we reach municipal solicitors because they can really help public officials, public employees know what to do. So just looking for any and all outreach opportunities. As of the date of the memo, which was July 9th, the Commission's legal division has issued 45 advisory opinions this year. I want to just give some commendation to them because they are turning them around very, very quickly. I don't know what the average turnaround time currently is. Last year it was 90 days, which was well under what was set forth in the statutory timeframe. So kudos to Bridget and Martin for doing that. It really matters for people. We've gotten feedback. You know, I don't want to move forward on this project or this issue until I find out, and they're just so happy to get those advisory opinions turned around really quickly because it allows them to live and move forward and do what it is, you know, that they want to do. So it's great.
Just wanted to shout out Martin, and again, he will give me a glare for this, but we've had occasions where he literally received a request for an advice of counsel drafted the same day, and it went out. So people have been very, very pleased with customer service.
Thank you to both of you.
That's so important because we want to encourage people to ask for advice so that they don't get afoul of the Ethics Act. And I think the message should be loud and clear. If you ask for advice, we will help you and ensure that you have the advice you need. So thank you guys for that. It saves us from some time spent later on.
With regard to investigations, which is, there you go, people don't ask for the advisory opinions. So far in 2026, we've opened 23 preliminary inquiries. I have an update from the memo, 5 of those have been opened to full investigations, so we continue to move forward on investigations. With regard to lobbying enforcement, we made a push over the last year to have continued communications with the Department of State. We jointly administer the lobbying disclosure law. And they've been great. They've been, I think, really useful for us and hopefully useful for Department of State. We actually issued, for the first time this year, a joint lobbying disclosure annual report. We thought, hey, if I'm interested in lobbying disclosure, I don't want to read 2 reports. I want to read 1 on lobbying disclosure. So we worked together on that, and that has already been issued. Although we do still reference it in our own annual report. We are looking for better ways to log calls regarding lobbying. That's something that was a bit of a sticking point, logging our communication, so we're still working on that. So far this year, just to give you a sense of numbers, we've issued a total of 27 warning notice letters to principals regarding their failure to file quarterly expense reports. 8 of them did not file their quarterly expense reports or otherwise comply with warning notice letters within the cure period. And we are, then we seek the assessment of monetary penalties against non-responding principals through the filing of notices of alleged non-compliance with the Commission, as you have dealt with already today in this public meeting. We continue to refer matters to the Attorney General's financial enforcement section. We haven't had a ton of luck with that. We've collected $750 in civil penalties for our office since the beginning of the year. We continue to communicate with them on cases, and we'll continue to monitor that and make sure that, you know, we are actually getting an outcome for those referrals. As you know, we've rolled out the new online SFI filing system as a pilot in January. Thank you. A few of our commissioners actually used it. I appreciate that you did that and that you provided us with feedback. We've also received feedback from the other pilot users. We've adjusted and we are working with them to kind of fix those bugs in the system. With the budget that we received for this fiscal year, we're able to do the full rollout in January 2027, and we are looking forward to doing that. We're excited to make that available. It'll make filing easier for everyone that uses it. And a couple of staffing updates. Our receptionist and clerk typist, John L. Whitney, left commission employment on April 24th to accept a promotion with the Department of Labor and Industry. We're very sad to see her go. She was a great receptionist, great colleague, and really worked nicely with the public and represented the commission well. We also received notice, very sadly, that our long-serving administrative officer, Sam Weaver, will be retiring from Commonwealth employment in early September. Very sorry to see Stan go. As a result of these staffing changes, we've reallocated and reworked the position description for John L's position to include some of the duties that Stan currently performs, so that he has the opportunity to cross-train someone that we're gonna hire. We have posted the job position, we got resumes back, and we're in the process of conducting interviews, so hopefully we'll bring somebody in shortly. We also have an open position on our investigative team here in Harrisburg as a result of Dan Bender's retirement. We had a tremendous response to that position, that posting. We are working through the resumes, hoping to schedule some interviews, probably not next week, but maybe the week after. We have some great candidates, and I'm excited to have a full complement on our commission staff. So we'll keep you up to date.
Should we move to our recommendations for staff pay increases?
Yes. So, as a result of the budget being passed, I am requesting commission approval for a 2% general pay increase, retroactively effective to July 1st, 2026, and a one-step service increment increase representing a 2.25% pay increase to be effective in the first full pay period of January 2027 for our commission staff. These increases that I'm requesting would be consistent with those that are set forth in the most recent AFSCME master agreement, which covers the time period from July 1st, 2023 to June 30th, 2027. The terms of the master agreement generally dictate pay increases for all union agreements within the Commonwealth. Typically, those pay increases are also extended to non-union and management employees across the executive branch. All of our commission employees are non-union, so we are not bound by the terms of any ratified union agreements. However, the commission has historically extended equivalent pay increases to commission staff. When we formulated the commission's budget for the 2026-2027 fiscal year, we built these planned increases into our request, our budget request, and we have sufficient funds to cover up both of these requests, both of these increases. I would like to note that neither me or our chief counsel are covered within the Commonwealth Standard Pay Scale, and therefore we are not requesting these same bumps. We are not included in this. Attached to the materials is a roster of our agency employees reflecting their date of hire, position, and current salary. I've also included the Commonwealth of Pennsylvania's 37.5-hour standard pay schedules that are effective both July 1st, 2025, and then the new one that is effective July 1st, 2026. Happy to answer any questions that you have about my request for these pay bumps for staff.
Questions on the staff request for pay increases? Hearing no questions, I'll make a motion to approve that recommendation of the staff pay increases as articulated by Mary. Can I have a second?
Second.
Would that include chief counsel?
Let's take that up separately.
Okay.
Next. So this is just on the staff pay increases. We have a motion and a second. Any questions or discussion? All in favor, say aye. Aye. Any opposed? No, that motion carries.
On behalf of staff, thank you for keeping their salaries the same and accounting for the increase in cost just for basic living expenses. I mean, it's the staff greatly appreciate your support.
So on a related matter, I'd like to take the opportunity to raise the salaries of where we are with our executive director and chief counsel. Dave and I had a chance to discuss this as the officers of the commission, and I think I had sent to all of the commissioners the latest evaluations of both our executive director and chief counsel. Dave and I have not yet had a chance, other than at a very high level, of going over the details of those evaluations, that I'll say publicly that for another year in a row of getting these evaluations. They are extraordinary for both our executive director and chief counsel. And we also looked at the current pay, which I think I distributed to everybody, including historic increases for the executive director and chief counsel, and also tried to compare it across the Commonwealth for other agencies and executives. And I think it's important to keep in mind the parity and responsibility across other agencies rather than just for those two positions, look at general pay increases or step increases. From a general pay and step, I think we're already equivalent across the agencies. And I would not recommend, and I think this is jointly on behalf of Commissioner Redcliffe and I, a general pay or a step, just because when you look at other agency heads of equivalent agencies, we're already comparable salaries. But in light of the evaluations that we received, I do believe a merit increase is appropriate. And in discussing this with Commissioner Redcliffe, we would recommend a 2.5 merit increase for both our executive director and for our chief counsel. We think with that merit increase, one, it's well-deserved, but two, it also would be equivalent with other agency heads and not out of parity, not knowing that, how other agency heads are performing, but certainly a fair recognition of performance without raising an increase that would not be fiscally responsible for the commission. So with that introduction, I'll make a motion to authorize a 2.5% merit increase retroactive to July 1st of this year for both our executive director and our chief counsel.
I'll second.
Okay, any discussion?
I think both, you said it well, both Mary and Bridget do exceptional jobs under difficult circumstances at times, and I think that's,
Any other questions or comments? Hearing none, let's take a vote. All in favor, say aye. Aye. Any opposed? That motion carries.
Thank you very much. And for the kind comments.
All right, we are now, want to take a moment to recognize our former commissioner chairman, John Bolger. Now, I see Mary's name's listed on this. Are we deferring to Commissioner Caruso on this?
Yes, please. I actually suggested that Commissioner Caruso provide the statement as he has known former Commissioner Bolger for many years, former Chairman Bolger for many years.
thank you. As many of you know, John Bolger served as a member of this commission from October of 1998 until his service was completed in 2015. He initially was appointed by Governor Tom Ridge and was reappointed in 2002 by Governor Mark Schweiger. John honorably served this commission for 15 plus years as a member, vice chairman, and his last 3 years were as the chairman of the commission. And while I interacted with John quite a bit while he was a member and as vice chair, I got to know him best or closest during the 3 years he was our chairman. And learning experience for me, and something that I will always treasure. It taught me to be a better person. But when John, just a couple little things, when John took over in 2012, we were in a little bit of turmoil. We had commissioners were being replaced, and we practically had an entire new commission. We had some pretty extreme budget problems. Staff was leaving. Mary was working with us around that time. Mary left, and we had our director of administration leave. But John was pretty calm leadership. He stressed on how we all had to work together. He challenged staff to do better, and he was the first commissioner to ever bring up, well, you know, maybe the General Assembly and the appropriations people in the governor's office really doesn't know what we do. And so they organized, and the commissioners like we have today, commissioners with expertise in dealing with appropriations and have worked or are familiar with the General Assembly, he got everyone organized, and that started us to a path of a healthy budget in which we're able to operate now. Another great thing John wanted to do, John pushed for the online filing of statement of financial interest. That was really a big thing for him, and he pushed for us to work with the General Assembly and with other stakeholders in this seeking feedback. And you know, we didn't have a lot of money yet back then, but we did establish a little bit of a rudimentary system that worked for us. And we did get some pretty decent comments about it. But the area where I think that struck me the most about John Bolger as a man was he was always cognizant of the work of the SEC staff. He came into the office quite a bit because he just lived over in Camp Hill. And he always addressed staff, but no matter who it was, from the clerk typist up to the executive director, by their first name, asked them how they were doing, always engaged in conversations. He remembered birthdays, special events. He would occasionally come to staff Christmas parties. He would sing Christmas carols, and it would give staff scratch-off lottery tickets as Christmas presents. Just was a wonderful man. And probably what most of the staff will remember, like LaShawn and probably Marty will remember, is that Bolger would come by every now and then and he'd call me and say, hey, send someone down, I have something in the car for you. And it would be, he called them Bolger's Buns, which were sweet rolls that he got from the West Shore Farmers Market in recognition of things that staff would do. It's just, he did the little things that made people appreciate him and like him best. But I wanted to share, Mary sent it to me the other day, and I had kind of forgotten about it when John left the commission in 2015. He sent me a handwritten note that he wanted distributed to the staff and to the commission, and I'd like to read it with the commission's indulgence. Dear Rob and entire commission staff, I assume by now you all know I will no longer be serving on the Ethics Commission. I just wanted you all to know that after 15 years of serving, I sure will miss you. You have been like family to me, as you know my name and I know yours. More importantly, you were always very professional. Thank you very much for your support and cooperation over the years that I served as a member and as chair. I wish you and the commission continued success. Perhaps someday our paths may cross again. I would like that. In the meantime, there will always be a place in my heart for you and the commission. It was my honor to have served with you. That kind of says it all, but John was always involved in community causes with Holy Spirit Hospital, Central Pennsylvania Hospice, American Heart Association, United Way, and his church, Good Shepherd Parish. Lastly, I think John would be upset if I didn't mention he was a proud graduate of Notre Dame, was a member of their Glee Club, and was named as the Notre Dame Club Man of the Year. John had 2 daughters, 4 grandchildren, and was a devout family man, and family always came first to him. I believe he'll be missed by them and all who knew him well. He was an outstanding leader, a great mentor to me, and a better friend. Thank you.
Thank you very much. So I know we don't have public comment formally on the agenda, but I do see a number of guests in the audience. Anyone have any questions or public comment before we close this meeting? Seeing none, how did Commissioner Jumper do for his first meeting on the commission? I'm seeing mid-level reviews. We'll have to
That's better than I used to get.
We'll have to work on that. May I have a motion to adjourn our public meeting?
So moved.
And a second? All in favor?
Aye.
Okay, we stand adjourned